Thank you, Your Honor. Before you today on State versus Darrell Williams, file 25 CR 921. We're here today for a motion to suppress, but it's anticipated by the state of Ohio that the defendant will withdraw that motion to suppress. And furthermore, for his client to enter a plea of guilty to count 2, a lesser included offense of count 2 in which the state of Ohio would ask you to add the attempt statute to count 2 as indicted under 292302, which would render count 2 attempted tampering with evidence a felony of the 4th degree, and the defendant will plead guilty to count 3 as indicted possession of cocaine, and the state of Ohio would move the court to dismiss the remaining counts at sentencing. Other than a pre-sentence report, no threats or promises are made to this defendant to induce his plea. Thank you.
You have count 3 listed in the paperwork as a felony of the 5th degree. It's indicted as a felony of the 4th degree.
Oh shit, I'm sorry, it should be a felony of the 4th degree.
Okay. All right, Mr. Smith, is that your understanding? My understanding is you had agreed that you're pleading to a lesser included offense of count 2 as well as count 3, so both will be felonies of the 4th degree. Is that correct?
My understanding goes to F4 and F5.
It is.
Well, then,
It is an F4. I told you possession and the attempted.
Okay. All right. Just 1 minute, Jordan.
that's what was discussed in Chambers, is it was going to reduce the felony of the third degree to an F4, and he pleaded that as well as count 3. That's what was discussed in there. I mean, I wasn't a part of your discussions, but that was what.
Okay.
It was never said in Chambers that both counts were being reduced.
No, okay, yeah, I understand that. Okay. So it's still but it's not going to change. Okay. So as I understand, it's 2 F4s?
Yes.
All right. Yes, Your Honor. But I don't know if the prosecutor stated in regards to forfeiture or not of because we discussed the funds.
Yeah, it's still forfeit.
Okay, yeah, I'm not.
Well, put that in the record because that's part of the deal here, right?
Yeah, it's on the complete paperwork.
I know, but when you just said that other than what's been said on the record, there's no other agreements, and that's not true.
Oh, the other agreement would be he's forfeiting the EBT card that was used in the drug transaction, the narcotics, and the $1,352 that were taken off of the person. Thank you.
And that's your understanding as well?
Yeah, that's correct, yes.
And most importantly, Mr. Williams, were you able to...
1 minute, John.
Mr. Williams, were you able to hear everything that was said here? I know
Yes.
it was going back and forth a little bit, but what's been represented is that you're going to be withdrawing your motion to suppress that was filed, and I'll explain all this more in detail here in a second. And then withdrawing your not guilty plea to count 1 and 2 and pleading count 2 and 3. in pleading guilty to a lesser or reduced charge of count 2, as well as count 3. Count 1 would get dismissed, the trafficking charge. We would continue the sentencing to a future day, get some evaluations completed, come back on a future day. Where there's no agreement regarding sentencing and regarding any amount of time or probation or prison, there is an agreement that you would forfeit the property that was seized from your person at that time, as well as the drugs. But in regards to any other sentence, each side's free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do here at this time?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any time when I'm asking you any of these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on here, all right?
Yes, Your Honor.
All right. Let's get started then. How old are you, sir?
39.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this afternoon, have you any drugs or alcohol of any kind?
No, sir. No,
What
no,
up?
sir.
I'm sorry?
No, sir.
Not
No, Your
even
Honor.
not even prescribed medications, nothing?
I take
Can you move your hands away a lot?
I'm sorry about that. I'm sorry about that. I take lisinopril for diabetes, for high blood pressure.
Lisinopril?
Yes.
You took
And,
that. You took that today or yesterday?
I took it this morning,
Okay.
and I take insulin, insulin. Yeah, and that's it.
So they take the 2.
I take metformin, but I haven't took that today.
Okay. Do either of the medications that you would have taken today affect your ability to understand or appreciate where you are, or what's going on around you, or to communicate or anything like that?
No.
Now, you would have been served with a copy of this indictment back in November of last year. That's the document or the paperwork that sets forth the charges you're accused of committing. Do you remember getting that?
Yes.
You had a chance to look that over at some point?
Yes.
Now, in that indictment, you are charged with 3 counts. You're pleading guilty to 2 charges from that. I'm going to go over those with you here right now. In count 2, what is alleged here, it's not what you're pleading guilty to, but what you're charged with, is on or about June 18th, 2025 in Willoughby Lake County, Ohio, that you, knowing that an official proceeding or investigation was in progress or is about to be or likely to be instituted, that you altered, destroyed, concealed, or removed any record, document, or thing with the purpose to impair its value or availability as evidence in that proceeding or investigation. That conduct constitutes offensive tampering with evidence. It's a felony of the 3rd degree. Do you understand what you're charged with in pleading guilt? Strike that. That's what you're charged with in count 2. You understand that?
Yes, yes, Your Honor.
Now, for purposes of the plea today, the state has agreed to amend this count to what's called attempted tampering with evidence. What that means is that you engaged in conduct that, if successful, would have resulted in the offense of tampering with evidence. And the significance of that is that it reduces it from a felony of the 3rd degree to a felony of the 4th degree, which is actually a big deal. Felony of the 3rd degree, you can get 3 years in prison. There's no presumption for probation. The attempted makes it a felony of the 4th degree, which the maximum sentence is it's 18 months, and there's a presumption for community control sanctions. Fine is a lot less, too. You understand the difference there?
Yes.
And you understand what you're pleading guilty to?
Yes.
Any questions for me about that?
No, Your Honor.
Now, count 3, you're also pleading guilty to alleges on or about June 18th, 2025 in Willoughby Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance containing cocaine. The amount was was more than 5 grams, but it was less than 10 grams. It was 7.71 grams. You understand what you're charged with in pleading guilty to in count 3?
Yes.
Any questions about that?
No, Your Honor.
Now, there is a first count of the indictment, a trafficking charge that's being dismissed. Is that your understanding?
Yes, Your Honor.
Any questions about that charge?
No, Your Honor.
Well, then before I can accept your guilty plea to the 2 charges I just read to you, I need to make sure you understand all the rights you're giving up. And you, first of all, have a right to have a trial in this case. Now, the trial could be to me as a judge, where I would listen to all the evidence and I'd make that decision ultimately whether you're guilty or not guilty of each charge. But you also have a constitutional right to have a jury trial, and that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those 12 jurors would consider and weigh all that evidence, and those 12 jurors would make that ultimate decision. That ultimate decision reached by those 12 jurors would have to be unanimous. That means all 12 of them would have to agree together, one way or the other, whether you're guilty or not guilty as each separate charge. You understand that?
Yes.
You understand by pleading guilty you're giving up your right to a trial?
Yes, Your Honor.
Now, if we had a trial, you have the right to have an attorney represent you at the trial. If you could not afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, Your Honor.
Now, also at a trial, the prosecutor here, he would be representing the state of Ohio, and he would have what we call the burden of proof. With the prosecutor of the state of Ohio having the burden of proof, what that actually means is that it is his job, or he bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I talk about this burden of proof, since it's a criminal case that we're dealing with here, the burden of proof is what we call proof beyond a reasonable doubt. It's the highest burden there is in our justice system. And what that really means is that it's the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges I just read to you beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes.
You understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes.
Excuse me. Now, in order to try to do that, if we were going to have a trial, the prosecutor here would be bringing witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask him anything he wanted to on your behalf within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request the court issue an order. That order we call a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if the person wasn't willing to come in voluntarily or on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision. That is a choice that you would have to make. Do you understand that?
Yes.
And what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, he's not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you don't want to. Do you understand that?
Yes.
Further understand that if we went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to another court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up you're giving up your right to appeal any guilty finding that I'll make if I accept your plea, as well as any other issues that you could have brought to the court's attention or did bring to the court's attention. For example, the suppression motion, you're withdrawing your suppression motion. What that motion is, I'm sure your lawyers explained it to you, but it's a request. It's a motion your lawyer made arguing that you had your constitutional rights were violated in some manner, and as a result, any evidence that was collected or found or discovered as a result of the violation should be suppressed, should be kept out of the trial. The state should not be allowed to use it. Your lawyer filed that motion. We were scheduled to have a hearing on that today. By withdrawing that motion and pleading guilty, you're giving up your right to raise that issue. You're not going to be able to bring it up in the future or challenge that issue anytime, at any point. You understand that?
Yes.
Okay. Any questions about that?
No, Your Honor.
All right. So do you understand all these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. You understand them all?
Yes, Your Honor.
Any questions for me?
No.
You still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? So it means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you will first of all be found guilty by the court of the charges you plead to, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, both counts you're pleading guilty to here are felonies of the fourth degree. A felony of the fourth degree is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes.
And since there are two separate charges here, if I did impose a prison term, I would impose a prison term on each count. And then as the judge, I had the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means together. You serve them at the same time. Consecutive means one after the other. You understand the difference there?
Yes, yes, Your Honor.
So in this case, if I gave you the maximum sentence on each count and ran them consecutive, you're looking at a maximum possible prison term of 3 years in prison. You understand that?
Yes, yes, Your Honor.
Now, are you currently on probation or parole, PRC, to any other courts or agencies?
No, sir.
Do you have any other criminal charges pending against you in any other court?
No, sir.
If a prison term were imposed, in this case, upon your release from prison, you could be placed on what is called post-release control, sometimes referred to as parole or PRC. It's a period of supervision you would be on after you completed the prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes, Your Honor.
And if you were on post-release control and you were violating any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence, there are other sanctions that could be ordered. You could be fined in this case. Each of these offenses carries with it a possible fine of up to $5,000. So together, that's a maximum fine of up to $10,000 that could be imposed. You could also be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
In regards to the drug charge, that also carries with it a possible, not mandatory, but a possible license suspension of up to 5 years. Do you understand that?
Yes, Your Honor.
And as was discussed, you've agreed to forfeit any ownership interest you have in the U.S. currency that was seized. I believe it was 1,350 something. $1,352.
52.
I saw that somewhere. Oh yeah, $1,352, as well as the drugs, and as well as, what was the other thing? Oh, the EBT card. You understand that?
Yes, Your Honor.
Okay. Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible. Prison's not mandatory or required with these charges. Both of these charges are probationable offenses, which mean I could put you on what is called community control sanctions, another name for probation. You understand that?
Yes.
Now, just because you're eligible doesn't mean that's automatically what's going to happen. It means I'll consider that if that's what you're asking for. I'll look at all the information presented, then I'll make the decision I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on community control at any point, it could be for up to 5 years. And as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes.
Further, if you are on probation at any point and you violate the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. And if it was determined that you were, we could extend your probation up to 5 years if it wasn't originally 5 years. I could order more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I sent you to prison at that point, again, it could be 6 to 18 months on each count. That could be consecutive for up to 36 months or 3 years in prison. You understand that?
Yes, Your Honor.
And that also could be consecutive to any other sentence you may be serving at that time for some other case, or that you're being sentenced to if there's a new case. Do you understand that?
Yes.
All right. Lastly, when we do proceed to the sentencing hearing, you're going to have the right on that day to say anything you want. Anything you want me to know, anything you'd like me to consider. Your lawyer can speak on your behalf. He's allowed to recommend the sentence to the court, provide whatever information he wants me to know. Prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, yes, Your
Do you
Honor.
understand that whatever the lawyers say, whatever anyone says, quite frankly, at the time of sentencing, regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that. Even if they agreed, I wouldn't have to follow that if I didn't think that was the right thing to do. You understand that?
Yes.
All right, well, do you have any questions for me about the potential penalties you face by pleading guilty here?
No, Your Honor.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with Mr. Smith? Have him go over the reports with you, discuss the issues, answer your questions?
Yes.
Are you satisfied with his advice and counsel?
Yes.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering your guilty plea freely and voluntarily?
Yes.
All right then, Mr. Williams, any questions for me at this point regarding anything we've talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to talk to your lawyer before we go forward with your actual plea?
No.
All right, then what's going to happen at this point? The prosecutor is going to explain for me what he believes the evidence would show regarding these charges you're pleading to. I want you to listen to him because I have some questions for you about that, all right?
Okay.
All right. Mr. Geigerich?
Thank you, Your Honor. The evidence would show that on June 18, 2025, Lake County Narcotics was engaged in surveillance at 6035 Somme Center Road in the city of Willoughby, Lake County, Ohio, which is a Sheetz. As they were watching, an individual came to the attention of Lake County Narcotics. They were watching him when the defendant pulled up next to him. Both males went into the bathroom and came out after a very short period of time. The male who originally came to the attention of LCNA was stopped. He admitted to Special Agent 94 that he had just engaged in a drug transaction with the defendant. At that point, Special Agent 22 pulled behind the defendant's vehicle to attempt to block him in. Prior to the defendant getting in the car, he ran. He was apprehended by Special Agent 22, and after he was apprehended, two bystanders came advised Lake County Narcotics that the defendant had tossed something by the propane tanks when he was running. The agents recovered a baggie of cocaine. That baggie of cocaine was sent to the Lake County Crime Library to test positive for cocaine in the amount of 7.71 grams of cocaine Schedule 2. Thank you.
So, Mr. Williams, were you able to hear what the prosecutor just had to say?
Yes.
Now I'm mainly concerned with, not with the initial transaction, but with your, what he said about when you were running away and what you did at that point. You heard what he said about what you did at that time?
Yes.
And what, if anything, did he say about those facts as he presented them? Are they true? Did you do what he said?
Yes.
Very well, then, regarding the lesser included or reduced charge of count 2, charging with attempted tampering with evidence, a felony of the 4th degree, what is your plea to that?
Guilty.
Regarding count 3, charging with possession of cocaine, a felony of the 4th degree, what is your plea to that?
Guilty.
All right, I have in my possession at this time a document, 5-page document called a written plea of guilty and judgment entry, which sets forth everything I've just talked about with you. Mm-hmm. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is you had a chance to go over this before I walked out here. Is that correct?
Yes.
Mr. Smith, you went over this with your client?
Yes, Your Honor.
I'm going to hand this back to you at this point, though, because I made some changes. On page 2, it indicated initially as an F5, but it's an F4. Then on page 3, I changed the potential penalty at the top as well as the total amount of time and fine. So go over that with him. I'd like him to initial those spots, please. So page 2 in the middle, on the right-hand side there, I've made a change from F5 to F4. And the top of the set third page, and then the middle of the third page.
Right here too.
Yes, and then the top there too.
Right here.
Yeah.
Any questions about any of that, Mr. Williams?
Yes.
No, Your Honor.
Yeah, right there.
Right here too.
Yeah, right there.
Okay.
Now take a look at the second page real quick. Just I added in there also just the page 2, the medications that you're taking. So that's been added as well. You don't have to initial that, but there's a point there. It said initially that you hadn't had anything within 48 hours, and I said except for the lisinopril and I forget what the other one was.
Metformin.
No, I didn't put metformin because you said you hadn't had that.
Right here.
Pro.
Right there. You can initial right there. So.
Yeah.
What's this?
Insulin.
Oh, insulin. That's right. Insulin and lisinopril. So, you can turn that back over to the bailiff. So, Mr. Smith, you reviewed this document with your client,
Yes, I have, Your Honor.
and did he indicate an understanding of it to you when you did that?
Yes, he did.
Is that correct, Mr. Williams?
Yes.
So you understand what this document says?
Yes.
Do you have any questions for me about it?
No, Your Honor.
It also appears you signed the document. Did you sign it?
Yes, Your Honor.
And Mr. Smith, you witnessed that?
Yes, I did.
Mr. Geiger, you as well?
I did, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open courts with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of the lesser included offense of count 2, being attempted tampering with evidence, of felony the 4th degree in violation of 292302 and 2921.12a1. I also accept your plea and find you guilty of count 3, possession of cocaine, of felony the 4th degree in violation of 292511 of the revised code. I'm going to defer sentencing. I'm going to order a pre-sentence report and investigation, drug and alcohol evaluation. And I believe, Mr. Smith, you wanted to be heard on the matter of bond.
Yes, Your Honor. If we can be heard on bond.
Go ahead.
At this time, we're asking that my client's bond be reinstated and/or he be put on GPS monitoring, so he have a considerable, so he can have time to take care of his affairs prior to sentencing. He does acknowledge on a prior date that he did not show up to court. I believe December or January 5th.
It was January.
January 5th he was supposed to come, and he definitely acknowledges using bad judgment and a misstep in regards to that. But moving forward, he definitely promises to appear at any and all court hearings. And like I said, he's willing to do whatever it takes to abide by the conditions of bond as well as GPS monitoring. So we're just asking that the court abide by that request, and he will be here for sentencing in May. Thank you.
You have a driver's license, Mr. Williams?
No, sir.
Well, one of the reasons you didn't show up was when you called, you said you had no transportation.
Yeah. At that time, my lady did not have a car at the time, but it wasn't even just the
I
transportation.
know you weren't feeling well also,
Yeah.
but you were sick and you had no transportation.
Yes.
That's not an excuse.
I know.
That's not going to cut it. I mean, if I give you a bond, you're representing that you're going to be able to get to court, you're going to be able to get to your appointments. And if you don't have a license, you're going to walk here if you have to. You're going to take a lake train if you have to. You're going to get a ride, but you're going to get yourself here.
I understand.
Because we can get you here very easily, as you saw today.
Trust me, I know.
I mean, there's not going to be any excuses for not showing up.
Not at all.
Or there were last time. And those aren't going to fly.
And I apologize about that, Your Honor.
So if I reinstate the bond, you obviously have to show up for sentencing, but before sentencing, there's going to be some interviews you have to go to the probation department for.
Yes.
And I'm going to explain that here in a second, but if you don't do that, they can't do a report.
Okay.
And if they don't prepare a report, the law doesn't even let me consider probation as an option. My only option is prison. And I won't continue the sentencing to another day to get this report done because it wasn't done initially because you didn't show up when you were supposed to. You understand
Trust
that?
me, Your Honor, I never had no intentions on not to come at all.
Yeah, but then you didn't show up after. That's the problem.
That's my
I mean, if you were, I don't want to suggest you, I guess, say you were lying, but if you were truly sick and couldn't get a ride there, you could have, turned yourself in immediately and you would have been back out on the street.
Trust me.
But you stayed out for at least 5 weeks before you 6 weeks before you turned yourself in.
Yes.
Which then shows me that I don't know. It's skeptical.
No, only reason why, Your Honor, I promise you, it was just I was kind of skeptical of Mr. Chad Markey, and I got with Mr. Sam Smith, and I just wanted to come up on some money with my lady's help, with my lady and my son help. They helped me pay for the lawyer, and I just wanted to get him paid for and retained. And the day I did that is the day I turned myself in. I just was skeptical about Mr. Chad Markey.
We just need to make it clear. I don't want to.
I apologize about that.
But we need to make it clear that it's not your lady's responsibility to get here to court. It's your responsibility.
Right.
And if she doesn't have transportation, you're going to have to find some other way of getting.
I'm going to
that's
get
not. That's not an excuse. All right, I'll reinstate the bond at
Thank you, Your Honor.
$50,000 cash surety 10%, but I'm adding a condition of GPS monitoring. So you're going to have to get hooked up to a GPS monitor. Your lawyer was given the information here before.
Okay.
And so what that entails. So that you're not going to get out today, but very well could get out tomorrow as long as you get that. It's on you as the one that gets set up.
Okay.
And Your Honor, you said I go over to the jail to administration office to get that info?
Well, you mean?
Yeah.
You can go to probate. I mean, we talked with Mr. Berry, but I'd go over there and get the information for the particular companies and the phone numbers.
Oh,
I'll
okay.
give that to you.
All right.
He won't be able. He won't be able. to
Yeah, I
do it
understand.
now.
I understand.
But you can go over there. It's the third floor on the right hand side when you walk in the jail.
Okay.
Just go up there. I'll give him a call. His name's Craig Berry.
Okay.
I'll give him a call again and let him know that you're on your way over just to
Okay,
get the
thank you.
information you need. So here's what you need to make sure you do, though, Mr. Williams. When you do get out, if you have not met with probation yet, and if it's tomorrow, you probably wouldn't have met with them yet. If it's a few days, maybe you will.
Right.
But this is on you. If you have not met with them yet, you need to go right over there when you get out, assuming it's during the working hours, before 4:30. If it's after that, then you need to show up that very next morning.
So if I get out tomorrow before 4:30, I go over there before 4:30.
It's in the same building that you're going to be in. You're just going to come down that one side. You walk over to the other side of the building. There's an elevator right there, and you take it up to the third floor.
Okay.
So when you get out, it's before 4:30. You go see them. You're going to meet with them. You're going to fill out some initial paperwork, and then you're going to get a date to come back.
Okay.
And that date to come back is for your interviews.
Okay.
If you don't come back for that, then there's no report, like I mentioned before. When you do meet with them, when you come back, make sure you're open and honest with them because they're going to check and verify everything you tell them.
Okay.
If they learn you're misleading them in any way, they're going to let me know that, and I obviously consider that as sentencing. You understand that? One other condition of your bond is that you don't use any drugs while you're on bond, and you should be completely clean now. Maybe you were clean before, but there's no reason there should be anything in your system now.
Right.
They're going to take a urine sample when you come back. If it's positive for anything, even marijuana, your bond would get revoked and a warrant would be issued, and then obviously be considered by the court as well. You understand that?
Yes.
All right. Now, if probation does come see you before you go out, you'll make all those arrangements with them, and you'll know what day to come back. Then you don't have to go see them. You just come back on the day that you picked with them.
Okay.
My guess is you'll probably have to go over there. You'll probably get out before they would come see you, if it's going to be the next day or two.
Right.
And then for the record here, Mr. Smith, you're withdrawing your motion to suppress at this time?
Yes, Your Honor.
Okay, that will be withdrawn. And count one will get dismissed, but that'll be dismissed as sentencing.
Okay.
I think that covers everything. Mr. Geigers, is there anything else I need to address here? Oh, I think we already canceled the bond forfeiture hearing. That's already been canceled, okay. It was a bond forfeiture hearing initially set when he failed to appear, but that was, he turned himself
So
in.
you want, in the entry, do you want motion to dismiss withdrawn after bond, or do you want it at the beginning?
We can put it at the end. The motion to suppress is withdrawn. Motion to suppress, not dismiss, but motion to suppress.
Yes.
Either one, it's fine. Okay. Mr. Smith, anything else?
No, Your Honor.
All right, I'll give Mr. Barry a call, and let you know, but you can.
Okay, I'm
head
ahead on it. Okay. All right, thank you.
Can you call her?
Yeah, I am. I have to wait a bit first.
Tell her to call anybody.